with this, we'll invite our next speaker. That's
yeah. Hi,
he's here. She's
yeah.
here. Sorry. Yeah.
Hi.
Yeah. Wait just a minute. I think. Okay, she's here. Okay.
Yeah.
Good afternoon, Miss Hana. How are you?
I'm good. What about yourself? Can you hear
Yeah.
me? To start with?
I think you are part of this session since the beginning.
Mm-hmm.
Yeah, I just noticed in the middle of the session. By the way, welcome to Symbiosis family, and Symbiosis School of Construction Engineering and Infrastructure Management invites you from the bottom of our heart. And thank you for joining for the today's webinar. And I'm really grateful that when we had a conversation and when I asked you that, are you willing to come forward and address the students, and you immediately said yes, why not? So for those who are just joining, all the participants, welcome. So everyone out there listening, I think when we have such great and knowledgeable and helpful speakers in front of us, I cannot say that, you know, give an applause, but definitely everyone just type a quick thank you message for Miss Hana in your chat box that she took time to, you know, come in front and address to you. A quick thank you. A quick thank you.
Yeah, that's very, very kind of you. I think I went to Pune in December to be part of your other event, right?
Yeah, we did meet. Yeah, I think that was in December, I guess. I guess.
That was in December.
So I'll give an opportunity for a minute to our director, Mr. Aniruddha Dubal, to give a welcome message. Okay.
Sure.
Yes, sir, you are there.
Hello.
Hello,
yes.
sir.
Good afternoon.
Good afternoon.
Thank you. You are took a time for the discussion with our Symbiosis family, and I am very thankful, and I'm welcome to from my bottom of heart. Welcome to Symbiosis family.
Yeah. Thank you, sir. Thank you so much. Yeah. So I think as we had a discussion, Miss Hana, that we'll be keeping this more of an interrogation or not interrogation, maybe an interaction. So there are some couple of questions which I think from your end, if you give us more knowledge and clarification on that, then we will, you know, we can say that, you know, today was a complete IP session. Okay. So I'll just quickly move down to the question and answer part. If I want to know that someone has, you know, taken a patent or filed it, how long do patents usually last for? And what about copyrights and trademarks?
So I would start with continue to what Mr. Ram said. And this is something which I would like everybody to bear in mind when we are talking about IPR. So IPR is, and it doesn't matter whether we talk about patent, trademarks, design in the West or in many countries, we would have what we call utility models. Is essentially a right which enables the rightful owner to sell, license, to use, to import. It also implies to import the particular product or method of concerning the product. So the third party cannot do that without the permission, right? And each country would have a different, I think in general it has been pretty much uniformed all over the world, but there would be a certain period of time for which that particular protection is valid. So in case of a patent, it's for 20 years. In case of the trademarks, it's for 10 years. Trademarks are a little bit particular in the way that you can, the moment your 10 years tenure is over, you can extend it numerous of times. For designs is for 10 years with the extension for 5. So each of these copyrights is for 20. So with each of these patent rights, there will be a particular period of time for which you can use it. And in terms of commercializing and prohibiting others to use your technology or your whatever. I mean, if we are talking about copyright, we will be talking about using the book, right? So each of them would be used for the different period of time. And the moment that that particular IPR expires, you can say, then the third party, whoever it is, can use your technology or product, whatever, without having to pay any licensing fee to you. Yeah.
Okay. The next question is, if a company develops a new technology that improves its main product, what type of intellectual property can they use to stop others from copying their own invention?
So when we are talking purely about technology, then we would be talking about patents, because patents are essentially, I mean, obviously when you talk about engine, improving efficiency or improving whatever in the engine, what you can do there. You would not have any other right where you can use it for you, right? So it would be patents. And now, so there are always ways how to look at it, because when you are looking at a minor improvement, it has to be still big enough to be able to file a new patent application. When you look at the patent law, I mean, particularly India, I mean, I always practice in India, so it might vary in a different country, that when you are writing your claims, so the improvement must be significant enough. So the patent examiner doesn't say that this new improvement is, let's say, obvious, because there are, of course, criteria on which you are judging a patent. First is the novelty. The other one is that it is, patentable as per the subject matter. The other one is that it's non-obvious and it's industrially applicable. So if I have a new, let's say, improvement to already existing technology, but it is very minor, that would not be enough to have it patented as another technology. Because essentially, when you are judging your novelty and obviousness, you are looking at something which is already existing. You are comparing it, right? So still has to be significant enough that for the examiner, it's a you can call it big step enough to be eligible for patent. Having said that, in different countries, as I said, like in Europe, many European countries would have what they call utility models. So utility models is somehow protecting minor innovation for around 10 years. India doesn't have this concept, so unfortunately here you either go only for design when you claim or when you protect just the visual part of it, or when you have to have a full-fledged patent when the technology is significant enough to have this type of protection. Yeah.
The next question is, does IP infringement always give rise to criminal liability, or just in terms of money? In which case can one party go behind the bars? Is there any alternate method of dispute resolution? I think this is basically if someone has copied your idea, maybe in terms of a patent or copyrights or something on, and someone claims let's say a case to the other party. So can that party go behind the bars in jail, or in terms of monetary, are there any limitations to it?
See, in terms of infringement, I think it always depends what you're exactly looking at, right? So it can be a little bit different approach when there is infringement of trademark. It can be a different approach where is an infringement of patents. Now, in terms of patents, you can have a involuntary infringement. We are talking somebody that I'm a startup. I come up with something, but I don't do my prior art, and I'm not knowingly infringe on somebody else. But that can be infringers who know they are infringing on somebody else, who literally go copy paste somebody else's technology, so they know that they are infringing, right? So when again the court starts, they would be looking at how this infringement came about. Generally, what happens, and this is also something which sometimes people forget, IPR or any sort of IPR protection, if you as a holder, be it patent holder, trademark holder, are not willing to enforce it, it's pretty much useless. So you have to be ready to go to the court to stop whoever is, or at least write them some sort of notice, whoever is infringing on your intellectual property rights. Otherwise, we are talking about growing the business and this and that, but this is only because these rights give you the power to stop somebody in case they are using your technology, your product, your trademark, whatever else. So when you're talking infringement, if me as a patent owner find out that somebody is infringing on my, let's say, technology, of course, it would be my, I don't want to say, it wouldn't be my right to go and stop them, because of course I spend my research and development, I spend my money to try up with the technology, I spend my money for the attorney fees, I spend my money for running the patent for 20 years, which is not, you know, these are very significant amount of money which you have to spend in order to have this protection in place. So it would not make any sense from my end to, if there is somebody who is using your technology, to not to stop them. Now, how you do it? So there are, again, different companies would have different approaches. Sometimes it only starts where me as a patent owner find out that somebody is copying my product. I can just send them a letter and ask them politely to stop it. I can also ask them and offer them license. I can say, okay, you are, you know, manufacturing the same floor, or you are using the same technology. I give you license and you can continue doing so. Because many companies actually use patents to, you know, as Mr. Ram gave example of Qualcomm, where they would be looking for licensing partners. I mean, I work for an organization which is coming from Europe, you know, where European companies are coming to India, you know, to the market, and they are looking for partners. So the licensing is a very much valid tool, and many companies are willing to do that. So, and yes, so they do ask them to stop, they do ask them to license the technology, and if nothing is working, then they obviously take them to court. Now, you know, again, it depends what it is. It depends, you know, again, I mean, I used to work for a law firm, and we would have a case of, you know, little shops that were in Sarojini Nagar here in Delhi, which were selling counterfeits for Louboutin. If you know, Louboutin are very famous French shoes, which are red from the bottom. So obviously, if Louboutin would ask them to stop it, you know, and the court would order the particular shop owner to pay, I don't know, 20 lakhs or 30 lakhs, 40 lakhs, whatever the fees were to Louboutin. For the foreigner company, this is literally peanuts. So sometimes it's also about your brand protection. It's not always about money and trying to get money out of the people who are infringers. Generally, it is about stopping them. Having said that, again, you know, what a lot of infringers do, and this is what I really got to know here in India. Presumably, I give you example, there is, and this is a real example, company A, foreigner company, which is making floor products. So they have this particular system of the floor system where, you know, which kind of is assembled in a particular manner. And then we have an Indian party, which is completely copying, pasting their product. And the Europeans basically were not able to stop them in the right time. And when they actually called a court action, at that point, the Indian company challenged their patents, that the patent is not valid. So sometimes what the infringers do, they would actually challenge the validity of the patent in India. So if they prove that the patent is not valid, then they can keep infringing, because let's say they say, okay, this patent was never valid, you know, it was never new, it was never inventive, whatever it is. So the moment they can prove that the patent is not valid and the court will, you know, acknowledges that that's true, that the company who was the initial owner loses the right to sue them for infringement. So usually what happens is very pretty dynamic process. You know, if the infringer is smart enough, they would always try to fight back in one or other way. And they would obviously use the system, which is in any particular country, to do that. So yeah, so this is also happening. Also, even though you're a company, you have a valid patent, you know, somebody infringes on you, they can actually challenge your patent in the country. And now, you know, when we look generally about infringement as such, particularly in India, foreign companies have such a hard time because they still feel that Indian system or the Indian enforcement is still pretty weak. You know, and they feel that, you know, they cannot really enforce their patents here. So sometimes they don't really actually see point of coming to India, you know, filing the applications in here if they are not, you know, obviously in the old times, it would took, you know, 4, 5, 6, whatever years for the patent office to grant the patent to start with. Also, I'd like to mention in terms of infringement, you can only sue somebody and stop them once a patent is granted. So if I am a company which files for a patent and it takes patent office 7, 8, 9 years, it means that somebody can infringe on your technology, on your product for 5 years at least before you are able to stop them by law in India. Now, past few years, there have been, massive changes in the way how Indian Patent Office works and so on. So we tend to see the grants much faster. So now you can kind of stop somebody quicker. But yeah, in terms of whether they can end up behind the bars, I would think, I am not litigation lawyer, so I don't want to really kind of be telling you something. I know that most all the infringements end up on monetary terms, so they would be asked to pay something. Unfortunately, this is still in case in India that the courts would give very low compensation fees. So particularly, if you are in comparison, I mean, to the Westerner standards, so the fees would be still very low. So generally for foreigner companies in India, it would be just matter pretty much stopping them than trying to, earn something from the loss of revenue. Yeah. So this maybe a little bit of.
I thought that was the last question which we are hearing, because it was a lot of so much of experience and exposure which you are sharing in just one, because I was aware about maybe as, you have been working in Australia or Czechia and then Germany, but that's you have been dealing with so many of the cases around. And I've also heard that you are aware you know to speak Czechia.
Yeah, well, so I am Czech. I came to India after I finished so I'm an engineer by background, yeah, like all of you. I finished my master's in aeronautical engineering back home, and I came to India in 2008. It was my first job. I mean, at the time I was looking for adventure, I suppose. And I somehow, and my first job in India was actually as a patent searcher. And that's why, when you asked me to come and talk about to students, I thought it was a brilliant opportunity, because when I was doing my degree at those days, something like IPR was not on the radar whatsoever. So I come from a very small country. If you imagine, Czech Republic has, 10 crore people, so it's a half population of Delhi. So we are a very small country. And in such a small country, the IPR would also not be something which companies would be thinking of. And we were not growing up with, thinking about somebody else's technology, somebody else, trademarks and so on. And I do meet also a lot of Czech companies which come to India, and they are very worried about, companies infringing on their technology. But then I ask them, do you do any, do you have any in-house IPR team? And they say no. And I always tell them, so how do you know that you are not infringing on somebody else? So it's always, for sometimes I feel that Western companies are not always 100% fair when they're coming to India, because except for Germany and other big countries like, Netherlands or let's say Belgium, Switzerland, where the IP is particularly strong, they are very mature economies. But if you're looking at the Eastern Europe, Poland, Czech Republic, Slovakia, Romania, Croatia, it's not something, where people talk about much either. So I think there is this need to educate, obviously, young people here in India, not only to kind of think about their IP rights, but also not to infringe somebody else's IP rights, but also back home, so we should not be just, saying India this and that if we, in our home countries are not also implementing everything 100%, yeah. So, and that's also, I think I consider myself a little bit unique, because not just I came here a very long time ago, but also the experience I got in India, like working as a patent searcher, then working for a law firm, which generally, you would not find as a common practice for foreigners to be working in law firms. So, that gave me very, very unique exposure. And yeah, so I have been kind of drawing my experience from that. Yeah.
Thank you for those kind words. I feel proud in a manner. In a way, I feel proud about India right now. But anyway,
well, you should be. You should be.
I am, but considering this perspective and hearing out from you, anyways. But it's a bit too late. When I got to know that you speak Czech, so I thought of saying, how do you say hi, ahoy, like that.
Ahoy.
Rano.
Yeah.
Like that. Yak se mat. That's
Jak se máš?
Anyway,
Yeah, how
I know that was just a in a funny way on a lighter note. But anyways, moving on to our next question: how does international community coordinates with each other in terms of patent? Like I'm an Indian and I'm filing an Indian patent. Can I claim someone in the US?
So generally, I would answer this kind of never-ending question, which always people have: is there international patent? No, there isn't. So each country would have their own patent system, and they would have their own patent law, and they would consider different subject matter patentable or not. Again, I give you example, if I compare it India, Europe, US. Like India as well as Europe, you cannot patent software. So software is not a patentable subject matter. In India, there is section 3K, which would not allow, so you can't patent code in India. Neither you cannot patent code in Europe. In US, I mean, somebody was telling me that now you cannot do it either, but there was a time when you could patent software. The same goes for business methods. Business methods were patentable subject matter in US, whereas they were never in India or in Europe. So what I want to say by that every country will have their own set of laws, how they define their patent system. Now, what you only have, you have a mechanism which would allow you to file your application in a number of different countries. So one of them is the PCT, Patent Cooperation Treaty. So you can imagine, it's just a process. It's a process which allows you from India to file your application in a number of countries. But they nevertheless, when they are looking whether they grant your patent or trademark or design, I mean, there would be different roads for those different rights, but they would always look at the local law. So basically the PCT is just a gateway to give you a bunch of patents. So let's say if I am an Indian inventor, I file my first application in India, and then I decided I want to file my application in, I don't know, Europe, US, Brazil, and I don't know. So I would go through PCT. So PCT would give me a tool where I can file in those 5 countries, in those 5 jurisdictions with a single fee. Of course, then once the application gets filed through PCT in those countries, I still have to pay separately for all these different jurisdictions. But this is just a tool. Otherwise, you would have to, individual file in one country, then you would have to individual file in another country. And then, so the moment you are looking at the bigger portfolio or bigger what we call patent family, it always makes sense to file it through PCT or for the trademarks, I think, Hague agreement. So for each of the different patent rights, there would be some particular, you can say, pathway or gateway, which would allow you to do that. But that particular IP right will be always judged in the particular country as whatever they criteria are. Yeah.
Thank you so much, Ms. Hana. Just one last quick question, because I think at 12:30, I'm so sorry about that we got delayed. We have another session at 12:30, and I've literally started receiving calls from other end. But just one last question: that how can a startup protect his idea or a process? Like for example, for Airbnb, I think we have this Oyo. For Uber, we have this Ola. And for other maybe food delivery systems, we have this Swiggy and other. So if I'm coming up with an idea as a startup, how can I protect that idea so that someone doesn't copy my idea? I'm not saying that all Indian startups are copied, but in case.
No, I would not dare to say that. I have seen pretty amazing Indian innovation. EBTC, my organization, we do work a lot with Mighty, MSH Hub, with the NASCOM and the Center of Excellence. And I mean, some of the ideas we have seen were really, really amazing and brilliant, Of course, in India, I mean, if we are looking at this unicorn or whatever they call the startups, we would be generally see some app-based app-based startups. Having said that, I believe that there are a lot of other technology-related startups. So when you are looking at the idea, you always have to look what it is, right? As I said, you cannot patent software. So if it's a software-based solution, then you cannot do that. I mean, you can, through copyright, you can kind of protect your code, but then as any good programmer, he would probably know that I can change my code there and there to get the same output. So It always really depends what it is, you know, whether you can use the patent protection or if you can build your startup as a brand, like Oil, for instance, or Uber. So obviously they would have certain technology behind it, but they're also branding themselves very much. So I think, you know, it's really worth brainstorming what the idea is, how it would impact the market, you know, how I'm able to scale it, and so on and so on. So from those angles, you know, there would not be same solution for everybody, you know. So everybody, you know, each startup, depending what they have and how they, you know, also on their funding, on the technology, whatnot, and then they would have to kind of see what sort of IPR they can be using. Also for some of you, because we are all young students and maybe some of you are already in startups or planning to do that, there are a lot of government schemes, particularly in the ICT domain. Mighty Startup Hub, you know, they have amazing schemes. They, you know, would also they reimburse your patent application. They also reimburse patent application abroad. So now India has a really, really good startup ecosystem, you know, and also if you do your research, you would be able to find support. So this would be actually my advice to you as a young people, you know, do your research properly. You know, I mean, even in India, there are a lot of government initiatives. There are a lot of different things you can do. And I think this, I mean, current government is very fond of innovation, and there is this what they call trend India is innovation economy, and they do realize that through the startups, through this, you know, grassroots innovation, they can achieve it. And of course, you know, the idea would be always that way, that at some point you can either leverage it in some other way, or you would be able to sell it. Yeah.
Thank you, Miss Hana. I think with that, I would like to also add, I'm not sure that, you know, you cannot, algorithms cannot be, you know, patented. That is what
Yeah. Algorithms and program as per se, section 3K.
So with that, I'll, you know, bring this session to an end. I'm really sorry about it, but we would like to have, you know, been taken many more questions, but unfortunately we got a bit delayed. But with that, I'll let my director, Mr. Aniruddha Dubal, who is my mentor, my guide, and my friend also indeed. But I'll let him, you know, put down the final line. So are you there?
Yes, sir. Samir,
Yes.
sir, am I audible?
Yes, you're audible, sir.
Okay. So it was indeed a privilege to have Miss Hana in person. So for her question and answer about the IP was full of wisdom and very informative session, ma'am. Once again, I thank you, madam, for having us sparing your precious time for all of us and my student. So thank you very much for being with us. Thank you very much.
Yeah, very welcome. And I apologize for not preparing any presentation. I just thought that I take it a little bit of free.
Not a problem.
That's
That is
fine. I mean,
that is not a problem.
we are thankful and grateful to you that, you know, you took out time and, you know, came out and came across students and speak more on IP.
Sure. And of course, in the future, you know, if you want to organize something, you know, on a particular topic,
definitely.
That again.
That goes without saying. That goes without saying. Definitely. Okay. So with that, I'll, you know, I think we'll bring this session to an end. And you know, how do you say Yiku you? Then that is what you. That is, you know, somewhat I can make you feel at home. That's, you know, otherwise. Anyways, whenever you are, you know, come down to Pune, you surely have to visit our campus, which is Symbiosis Skills and Professional University, and it's amazing. It's pretty, you know. You will love to come here again and again and we'll definitely call you for some symposium or let's say a conference on IPR. Okay.
Yeah. Hopefully when the Corona is over. You too. Take care. Goodbye, everybody.
Thank you.